Good morning. My name is Mohammed Abdulauf. I'm a family law specialist, dealing a lot in family law matters, making the life a bit better. And today I would like to interact with you, whereby we can deal with certain type of issues, and one of those issues are care and contact issues. The topic is how to win your care and contact case in the High Court. The reason why I'm referring to the High Court and not to the Children's Court, the Children's Court has a total different way of dealing with these type of matters. They are more, in my view, a court that are supposed to deal with serious issues where they could potentially place a minor child in foster care, in a place of care, remove the minor child from the parents, and so on. So they have their own procedures, their own way of dealing with custody and care matters and guardianship matters. So they will deal with a normal application, how to deal with a matter regarding care and contact in the High Court. Obviously, the principles that apply here could equally apply to the Children's Court as well. So you do not have to worry about that. I'm certain if I have to deal with how to win your care and contact matter in the Children's Court, that would be my topic. I don't think there will be much to discuss because there are other aspects involved as well. So welcome again, and please note that this webinar is streaming live on Facebook Live. That's one platform. People are posing questions. Thank you for that. I see 2 questions have come in now already. The questions on my whiteboard, on my screen, those are questions that people posed when they registered for this webinar. Those questions I'll deal with first. And we're also allowing live interaction via those who are on Zoom. If you are watching this webinar via Zoom, you are welcome to put up your hand and I will allow you to unmute your microphone and you can interact with me. The duration of this webinar is about 1 hour to 1.5 hours. We will not go beyond that. So hopefully within that hour and a half I can answer all your questions and deal with whatever concerns you have. So I'll deal first with the questions on the whiteboard, and then I'll deal with the questions via Facebook Live, and then I will interact with you via Zoom if you have any questions. So your voice will be streamed into the webinar, not your face at all, and we'll take it from there. So let's start. The first question that was posed to the first registrant that registered for this webinar goes as follows. Hopefully you can see it. I think on the Zoom, to assist you via the Zoom, I will just share that specific screen so we can be on the same page. Hopefully you can see it now via the Zoom. The question goes as follows. If a parent gives up his or her full parental rights and responsibilities in respect of his or her children, can that parent at a later stage recover his or her parental rights and responsibilities? Looking at that question, 2 scenarios come to my mind. The one scenario whereby a party relinquishes full parental rights and responsibilities on an adoption scenario, whereby the parent signs away full rights and allows the child to be adopted by a third party, and maybe with the other parent as well. Let's say the other parent married someone else and wants to care for the minor child with the other parent, but the other parent, the new parent, the step parent, has no rights. Then the step parent decides to adopt this minor child with the parent he or she married. That's one scenario. With regard to that specific scenario, my answer would be then you relinquish all rights and you cannot come later on and say, I would like to have my rights again. You've consented to adoption. You've signed off all your rights regarding the child. It is possible for an adoption order to allow for certain type of contact to continue post the adoption, but the adoption order will deal with that. Then I think specifically where this question deals with, not adoption, dealing with a normal scenario where a party might have approached the court and relinquished all parental rights and responsibilities in relation to the minor child. That was most probably done via an application to court, and one party said, I agree, or it was litigated and the court made an order that that a specific parent has no parental rights and responsibilities. Then the question that is posed is, can that specific parent come back later and say, I would like to have my parental rights and responsibilities back again? My answer to that is, it all depends on what is best for the minor child. So the academic answer would be yes, it is possible, it is theoretically possible. Even if a parent has signed away or agreed or consented to relinquishing all his or her parental rights and responsibilities, for example, not being able to see the child, not having the authority to consent for the minor child to be, maybe get to go to a school, to relocate, to apply for a passport. He relinquished all that parental rights and responsibilities. He done it in terms of a court order. But 5 years down the line, he or she believes, I made a mistake, or now I actually want to be back involved in the child's life. Many reasons could be for that. A reason could be that after he or she relinquished his or her parental rights and responsibilities, the relationship between the parent and the child has become, changed, became better. For example, let's say this is a case where the father signed away his rights. The father now is more involved in the minor child's life. And he says, no, man, I am now very much involved in the child's life. Yes, I made a mistake in signing my rights away 5 years ago. I want those rights back. The court will have to reassess the matter, and if the court decides it is in the minor child's best interest, the court will make such an order. I hope that answers question number 1. And if I did not, if you are watching this video via Zoom, you're welcome to later on call back in and ask me additional questions and we can interact. Question number 2. My baby's daddy have not been supportive towards the kids, so I want them to sign parental rights to me. How do I do that, and is it advisable? I will maybe rephrase that question, and hopefully I'm rephrasing it correctly. The father was not much involved in the child's life. Now the mother wants the father to sign over his parental rights. Why would you do that? Very many scenarios could come to my mind. One would be, for example, the father is hard to find. When she applies to schools, the father cannot be found, or he does not want to give consent. The father does not pay child support. He is not involved in the child's life at all. And at every corner, the mother has to consider, I now have to consider the specific father all the time, but he's not involved with the child's life. When I apply for the primary school, the father's consent is required. I must find him somewhere. I must lie to the school. I must say the father cannot be found, and the school maybe comes to my assistance. It becomes problematic. Now, a scenario like this I will deal with in 2 ways. The first question I will ask you, is there a specific problem which you are incurring? Or do you want to, for your own mental sake, have something on paper? For argument's sake, if there aren't any problems, the father is not involved in the child's life at all, completely, but there are no challenges. There's no challenges regarding the minor child being enrolled to school. The school understands. There are no challenges regarding the minor child, consent for various things, for example, an application for a passport. So there aren't those challenges, but the father is not involved in the child's life. Now, the factual scenario, the factor scenario, or the factor facts, or the facts applicable here, would be that the mother is a primary caregiver of the minor child. She is theoretically exercising full parental rights and responsibilities over the child. The question is, why would she want to go to court if she is the one? Many people go to court if there is a dispute. If one parent wants to have care or contact, whatever the case may be, and the other party is disputing it, then you go to court, then you formalize it, and the court will make a decision. But here we're dealing with a scenario where the party has factually is a primary caregiver of the minor child. So, under those circumstances, I would say, why do you want to go to court? Why do you want to formalize it? In a few years' time, the child will be 18 years old, and then you wasted legal fees. However, if there is a reason why you want to do it, a basis, for example, there's problems, consent issues. I cannot leave the province because the divorce order which I had specifically stipulates I cannot leave the province without the father's consent, but I can't get hold of the father, and so on. Then I would say it makes sense. So think about that question. You're welcome to pose any additional questions. When I said early on it made sense, then I would advise you to make an application to have sole guardianship right over the child. Question number 3. What is the process to follow when the other parent does not comply with the parenting plan that has been made a court order? Is it even worth laying a charge against them? This is a difficult question to answer based upon that, because I do not know what specific provisions are not being adhered to, etc. So what I mean is, are we saying that one parent is refusing another parent contact in terms of a parenting plan that was made in order of court? Remember, a parenting plan that is made a order of court is no longer technically a parenting plan, it's a court order. So it gets power after it was made an order of court. Then we're basically referring to a court order. Are we dealing with a scenario, I'll repeat myself, are we dealing with a scenario whereby one parent is not allowing the other parent to act in terms of this specific court order? For example, the court order says the dad can have contact every second weekend. The mother is saying, no, you can't have contact, despite the court order, despite the parenting plan in the scenario. Or are we dealing with a scenario where the parent who is entitled to have contact, let's say you're the father, decides not to exercise contact? What happens then? So those are two scenarios. And the difficulty with dealing with these type of matters are that, yes, I see somebody making a comment, load shedding, and I think my network also gave me problems early on. So if I do get cut off, please let's log on again. I should go back online again. But the load shedding is a bit of an issue, or some electrical issues within the city. So doing that would be, but could possibly be problematic. However, if a parent is refusing care and contact in terms of a court order, a parenting plan that was made in order of court, that becomes problematic. And under those circumstances, I would advise you to lay a charge of contempt of court. So, for example, you're the father, the mother refuses your contact based upon a parenting plan that was made in order of court. Go to the police station, lay a charge of contempt of court. There's a criminal way of doing it. Go to the police station, or the civil way of doing it, you make an application to court. I hope that answered that specific question. Let's go to question number 4. As I mentioned earlier on, I'll be dealing with all these questions, question number 7 and the what's on the Facebook questions, and then I will be interacting with my Zoom participants. So do not be shy, only your voice will stream through, and I think it's more meaningful because I can engage better. When posing the question, you are limited to a few words, few sentences. When doing the live interaction, you can go ahead, ask and I'll answer, and we can continue on that basis. Question number 4. This question is not necessarily a custody question, but because you pose it, I will deal with it. Is it reasonable to ask the court to consider pro rata adult expenses for the primary caregiver in relation to the partner for living costs? Example, pro rata rent versus 50-50. Now, my view always was that you do not decide on child maintenance amounts based upon fixed ratios, because child maintenance is dependent upon the means of the parties. The amount you pay is dependent upon your means. Therefore, it's possible for the mother to contribute 90% of the child's expenditure and the father 10%, because she earns 9 times, also 90% more what the father earns. Therefore, I have an issue with 50-50. You have to look at the circumstance of each case. You have to spend time mathematically and work out what is a fair amount to pay. Because clearly, what if the mother earns a small amount of money and now she's ordered to pay half the child's maintenance expenditure, and the father earns loads of money but he's also ordered to pay half? The mother will be prejudiced, and she's also left with a challenge and the obligation of caring for the minor child during the week. Therefore, I am full supporter of pro rata. You work it out based upon the actual expenditure, based upon the facts applicable. I hope that answered that question. I'm not going too much detail on child maintenance questions, but I should have dealt with that. Question number 5. How does supervised contact get phased in? What happens if one parent needs to relocate due to finding better or permanent employment? So those are 2 questions. I'll deal with the first one first. Supervised contact getting phased in, I think here we're dealing basically with time-wise. So When does supervised contact in principle, supervised or not, get applied? The whole idea is basically to ensure that the child is safe, or psychologically safe, physically safe. Psychologically, in the sense of, what if a child never saw the other parent for years, does not know the other parent? Mom has remarried with a new husband, new stepdad. Here, all of a sudden, the dad comes out of nowhere. He says, "I want to have contact," which he has a right to do, but the child doesn't know the other parent. Must the other parent all of a sudden have contact every second weekend, every weekend? The child doesn't know this person. So clearly, phasing contact makes sense. Maybe we start with once a month for 6 months. Then we go towards twice a month. Then we go towards, maybe every second weekend. Whatever the case may be. But it needs to be phased in for the child's mental and psychological well-being. Remember, we're focusing on the child. We are not focusing on the parents. So I hope that specifically assists you where that is concerned. I need to just do something. I'll stop the sharing quickly. And we can continue with the questions. There it is. But here we're dealing with a scenario of supervised, phased in contact. Now, when will it be supervised? For reasons I mentioned early on. Alternatively, if it's a young child, the child is not used to the other parent. And there needs to be somebody close by to ensure that the other parent can, properly engage and, deal with the child. So supervised contact does not mean you need to be in the same room watching the other parent. And the moment the child, makes a small sound, you need to come and reprimand the other parent and say, "How can the child is crying? Give the child back to me." And no, that's not how supervised contact works. You need to be in close proximity. If there are social welfare issues, if there are serious issues like sexual abuse, physical abuse, and so on towards a minor child, then I would say you need to watch. But if it's a normal scenario whereby the parent is not used to the child, let the child cry for a minute or two, because that's the only way the child will get used to this person, and this person will get used to, the parent will get used to caring for the child. You cannot hop up and the moment you hear the child cries, come in and try to rescue the child. The same way any parent, any experienced parent out there, grandparent, etc., knows kids cries. And you can try whatever you want to do. If the child wants to cry, the child wants to cry until the nappy change, until the child is fed. Therefore, you need to give that parent the opportunity to be able to learn and teach himself how to deal with a specific child. The same way, you can be an experienced parent with your kids. Give you another person's children, you will struggle for a few days or whatever amount of time to get used to that child. So that's where supervised comes in. So phasing in supervised contact, as I mentioned earlier on, the idea is to let the child be accustomed to you and be used to it, and it does not psychologically affect the child. And it might have to be reviewed a few times. Being supervised, I would say, depends upon the child's age. It's very important. And at the same time, you need to give the other party an opportunity to develop certain skills. Because the idea ultimately is for the child to be alone with the other parent and supervision not to apply anymore. Let us move on. Question number 6. Yes, that's it. Need help to get maintenance from the father as well as an exception at school. Another child maintenance question. You need to approach the maintenance court as soon as possible. So which court do you go to? You go to the court where you live, you and the child lives, or you go to the court where you work, wherever you work. That's where you go to. And you apply for child maintenance. The court will obviously ultimately call the dad in and look at your income, your expenditure, the child's expenditures, and the other parents' income and expenditure, and the court will come to a fair amount. That's it. That's the long and short of it. So my advice to you is approach the child maintenance court as soon as possible. Let us move on. Question number 7. What are parental rights of unmarried fathers who are staying with the mother before the child was born and 2 years later? What are the limitations of the children's court with regard to primary residency? So the scenario, if I'm understanding correctly, mom and dad, they live together, mom fell pregnant, child popped out beautiful, everybody's happy, they stay together for another 2 years, father was involved in the child's life, father, the relationship ended, put it that way, and they're no longer together. And now the question is, what's the limitations of children's court with regard to primary residency? Oh, the first question is, what are the parental rights? So in terms of the Children's Act, if you are married to the mother of the child, if the father is married to the mother of the child, automatically the father has full parental rights and responsibilities, meaning he has to be consulted and his consent is required regarding passport applications, relocation, those important things when it comes to a minor child, application for his school, etc. He has a right to say, I want to have contact with the child and to be involved in the child's life. That is it. And if the mother automatically, by default, she has full parental rights and responsibilities. The question is the dad. But we have a problem here. We can't cut the child in half. Once parents have separated, things are different. The father might live 10 kilometers away, 50 kilometers away. The father might have a certain schedule. The mother might have a certain schedule. The father may not be able to change a diaper. He might not have any experiences on how to medicate the child. Factors are different. Families are different. Everything is different. We can't cut the child in half. Therefore, we need to come to some type of a resolution. Although both the parents have full parental rights and responsibilities over the minor child, regarding the care and contact arrangements, that has to be workable under the circumstances. So in answering your question, yes, the unmarried father here has full parental rights and responsibilities with the mother, and we hope that they can come to an agreement. Okay, this is your weekend, this is my weekend. No, we skip this weekend because there's a wedding in the family. We skip that weekend because I need to be overseas, I need to do something, I don't know. The parties are amicable, they're understandable, they're reasonable as any person would be. The same way you're working at your boss, at your work. Sometimes your boss and you come to some type of a discussion regarding some issue, as to maybe, for example, whether or not you can come to work or whether or not you shouldn't come to work, but you guys come to an agreement. The same way regarding care and contact in relation to a minor child, the parties need to come to an agreement. But if they cannot come to an agreement, the court will get on board and the court will say, under these circumstances, considering the mother's schedule, the father's schedule, everybody's schedule, the needs of the child, the age of the child, what school he goes to, how far the school is, extramural activities, needs of the child, etc. One parent only has many people living in the house, therefore there's no bed for the child. However, contact could take place every second weekend, but the child will obviously have to come back to the mom during the night to sleep. So whatever the factors are, although you are co-holders of parental rights and responsibilities, a workable solution has to be implemented. And if you cannot agree on that, you and the other parent, the court will get on board. And I think I answered that question. And the limitations of the Children's Court with regard to primary residency, no, the Children's Court can make an order regarding that. There are no limitations regarding that. That was the last question that was posed to us via our registrants. And we had now 2 Facebook Live questions. I'm looking at it now and I will deal with the first one, which I have in front of me. The question goes as follows. What does a woman turn to for help when organizations and governments only refer you in circles trying to save your child and protect our rights? Everyone is fundraising, but they only send you to legal aid, zero assistance. Yeah, this is a very difficult question to answer. Lawyers generally, they study, they finish their studies, they get trained, and they open up a business and then they charge for these services. And some of them will do community work, maybe like webinars like this or whatever. And there are other organizations like Legal Aid and Legal Resources Center where those lawyers are also earning a living, but the organization itself is paying them. Now, the challenge you have is that one party might be able to afford private legal assistance, he's paid for his own lawyer, and the other parent would not be able to do that, and he or she must either represent himself or herself, alternatively make use of organizations like Legal Aid, etc. I do not know how to answer this question, but it is a concern to me. I believe honestly that the children's courts, the maintenance courts, the domestic violence courts should have lawyers there employed by the state to assist people with these type of problems. The criminal courts, you'll find it all the time. Most courts in Cape Town, there will be, sorry, in South Africa, they will have a Pacific legal aid practitioner at the Pacific Court appointed to that Pacific Court room. And if you are being charged for a certain offense and you appear in that Pacific Court, there will be a prosecutor, sorry, a legal aid representative in that Pacific Court or dealing with that court, and you can apply to the legal aid board and they will appoint your case to that specific person. But it seems to me on children's matters, etc., they just appoint the maintenance officer to try to assist you, or there are some clerks. But I honestly believe that should be the case. I don't know how to answer that question. It's a government question to answer. And I hope you do find some type of relief or help out there. I believe everybody is entitled to have very good legal representation when it comes to these type of matters. Unfortunately, for any profession, accountant, a doctor, a teacher, we all have, have to earn a living. But at the same time, there are organizations out there whereby they are fundraising and they are obtaining funds from the state or various organizations who are out there to assist you. That is why they are there. Put it that way. Okay, we have another question on the Facebook Live. I need to get to it quickly and I need to copy and paste it into our chat. Let me get it there. And please remember, you are welcome to put up your hand now already if you want to pose a live question via the Zoom platform. I'll be happy to do that for you, answer it for you. Okay, let's get to this question. Before I deal with that, let me see if there's anyone else who wants to join our Zoom. I think we're doing well on the Zoom. Perfect. The next question on Facebook Live goes as follows. If a parent refuses to sign school admission forms and any other form related to consent by both parents, can one apply to have the particular parent removed from the birth certificate as that parent? I do not think you can be removed from the birth certificate from that parent because that's a factual thing. You're the parent. Taking your name off the birth certificate does not make the child not having a mother or not having a father. You always have a mother, always have a father. So it's almost like someone asking me, they were married, they got divorced, can I change my details that I was never ever married or I was never ever divorced? You cannot do that. So changing the name take the name off the birth certificate, that doesn't make logical sense because then you say there is no father, the father is non-existent, or the mother is non-existent, there was no mother. It happens differently, either artificial insemination, whatever the case may be. But be that as it may, what you would want to do under those circumstances is approach the court and have the court appoint you as a sole guardian of the minor child. So you have two options. The court can either say no, keeping the father or the other parent, as a co-guardian over the minor child, but under these circumstances, for this specific case, for this specific school, for this specific enrollment into the school, mom, only your consent is required. And the court makes an order, and you show the order to the court, to the school will comply, and they will admit you based upon your consent only. However, if you see this problem arising every single year, or for extramural activities, or passports, whatever the case may be, I do not know, you might want to approach a court and say, these are the difficulties I'm having. Every single month or every few months I have a problem, judge. I cannot approach a court every time. Please take away the other party's guardianship rights when it comes to these specific aspects so that I can parent the child much, much better. I hope that specifically answered that question. And if it did not, you are welcome to make use of the Zoom. If I do not receive any questions via the Zoom, any hands going up, then and no further questions on the Facebook Live, I think I have a question on the Zoom, a typed question, and then we'll have to end the webinar and get ready for the weekend. Okay, let me get to the Zoom question so that everyone can see it. Here it is. The question is as follows. I see there are a few questions. If a parent refuses to sign school admission, that was a question I got earlier on. My apologies for that. let's go to the next question. I must be very manual here. I need to copy and paste. Okay, that's it. I'm seeming to have some problems copying it. Hopefully it'll work. Nope, it doesn't want to copy. It's very weird. Anyway, I'll read it out directly and we can take it from there. Me and my wife separated after she falsely laid a charge of assault against me, which she later withdrew. Okay, that's fine. She took the kids out of the home, I presume, in 2018, September, to the family home and enrolled them at a new school. I took the kids back in 2020 and enrolled them back at the previous school, at my home, and sent the elders to boarding school. I informed her even though she did not agree. In 2020, she never made any effort to visit the kids or ask the kids to visit her. I then reached out and the kids needs to see her. Reach out to her and asking her that, telling her that the kids need to see her. I took the kids to her in December, and when they were supposed to come back, she refused to return the kids, I presume, and wanted a family meeting to resolve our issue. She ended up enrolling the kids again in another school, and on my side, I am yet to deregister the kids pending the court process. Okay, I see where we're going to with this. The case is now at Children's Court after failed mediation from the Family Advocate Court. Should the court rule in favor for the kids to be returned back to me, do I let them finish school there or re-enroll them back at their school? Okay, that's a question. So the parties were in and out of court. The child was living with the mom, with the dad, mom and the dad. So the kids last lived with the dad, and they went to go visit the mother. The father reached out to the mother, and after the kids lived with the mother for a short while, she decided not to return the kids and enroll them at the Pacific school wherever they are residing. I presume this all happened now this year, of course, and they were now at school for the last 3 weeks or 4 weeks at the mother's new residence, or at the mother's residence or the mother's province, whatever the case may be. The question basically is, if he is successful at the court application, is it best to have the minor children remain where the mother is residing or return back to him? I would say strongly have the children return back to him. The reason for saying that is, if the minor children continue residing with the mother to finish a school term or finish a school year, whatever the case may be, then that becomes the new home. They are now rooted there. Things are developing. The kids aren't attending school and telling the teacher, don't advance me too much because I'll have to go back to a different school in a few months' time to my dad. Or don't enroll me for tennis, for netball, for swimming, for rugby, for soccer, for cricket, because I will be going back there. So my advice to you, if you are successful, this is from a strategic point of view. If you are successful, ask the court that the minor children be immediately returned to you and they continue school where they are at. If that is not the case, the children will be obviously advantaged in the mother's favor to live with her, and she can bring up a very strong case at the end of the year stipulating, you know, judge, thank you, you made an order previously, but now that things have changed, new circumstances, it might be best for the kids to actually down to remain with me. That's from a strategic point of view. But seeing that we're dealing with minor children issues, matters regarding children, it is what's best for the kids. So if it is best for the kids to live with the mom and to continue schooling there, and the professionals are recommending that, then I would say that should be the case. I have a question over here. I think it refers to the previous webinar. I emailed you last week. I do not recall receiving an email, but if you have emailed me last week, please re-email it or give us a call at the office and I will respond to that. My apologies if I didn't see that email. Additional question, I have been working with a social worker and facilitator. The sessions and outcomes seem to be centered around the parents agreeing versus the voice of the child. During social worker visits, should one approach the family advocate? So when you focus on when you're dealing with mediation sessions, or facilitation and so on, the focus is generally trying to resolve the matter between the parties. The parties need to resolve this matter, and the parties are the best parties or people to decide what is best for them. And if they can come to a solution on their own, which the facilitator might think it might not be best for the child, but the parties are coming to it and they will work towards making it work, then that ultimately, in my view, is best for the child. For argument's sake, if the parties come to an agreement that the dad will pick the child up at 4 o'clock in the morning and drop the child the evening at 10 o'clock the evening, for argument's sake, and the mother is happy with it and she thinks, it can work, it's workable, because maybe the child will fall asleep during the day, but the party said this will work for us and it will be in the child's best interest. The facilitator might think no, it's not, but it's not for her to decide that, because now she said no, I think you should pick the child up at not 4 o'clock in the morning, but at 8 o'clock in the morning. What does it entail? It means the father must change his work schedule, the mother must change her work schedule, she must be available at different times. All those type of technicalities or issues might arise because a third party is now getting involved as to what should be in the child's best interest, but the parties themselves found a solution. Under those circumstances, I would advise that the parties, that you do not need to take the voice of the child approach, because we're dealing here with facilitation. The only time you actually do take the voice of the child approach, from a very strong point of view, is when the party matter cannot be resolved, and now you start listening to what is best for what the child has to say regarding the specific matter. But if the parents, who are the parties who will be implementing the specific plan, will be the one caring for the children and the one that's dealing with these specific scenarios, they are best to decide what is best for the mind of the child and for them. But as I mentioned earlier on, if there is a dispute, if the parties cannot come to an agreement, etc., then we need to start listening to the child as well. Strongly listen to the child. I hope you follow where I'm going to regarding that. And the last question on the specific questionnaire, should one approach the family advocate? The family advocate will most probably try to mediate this matter as well. But the family advocates, my understanding is they do not investigate unless there's a pending court case, whatever the case may be. It will be silly for them to investigate a matter, every single matter that comes to the table, unless there's a pending court case and there's a purpose behind it. But they do try to mediate. So if the parties cannot come to an agreement, is unable to come to an agreement, and the matter is pending in court, then I would say yes, maybe ask the court to ask the family advocate office to investigate these issues and provide recommendations to the court. And based upon that, they will consult with the kids. But at the end of the day, they want to come to a solution that's workable for everybody. I hope that answered that specific question. I have an additional question. The parent I need to get to it. The parent who has primary custody has been brainwashed. The child of 11 years old, and the child does not want to go to the other parent. How would you handle this? The parent is also overclaiming the child's support. Okay, I read it verbatim because I don't have a chance to read it before the time. But be that as it may, the question basically goes here is 11-year-old child, one parent is brainwashing the child to say you shouldn't go visit your dad, or please don't want to visit your dad. So whatever the parent tells the child, at the end of the day the child comes to the opinion that I do not want to visit my dad or my mom. I do not see any genders over here. And then the other parent is also overclaiming child maintenance. So there are two issues over here. We're dealing with parental alienation, very difficult situation. You need to there are two ways of dealing with this. If there's a court order in place, you just enforce a court order. That's all that I'm saying. The child should not have a say over how contact should be exercised. For argument's sake, let's say the child lives with dad. Dad smokes cigarettes, he drinks. Life is good there by dad, and McDonald's and Kentucky, whatever the case may be. The child said, no, I want to be with dad, I don't want to be with mom. But at mom's home, there's schoolwork, there's homework, there's routine, there's well-being, they maybe do some yoga, you don't even know. There's sporting activities, there's everything that is good is at mom's place. but everything that's fatty and greasy and fun is at dad's place. Now the child says, no mom, I do not want to live with you anymore, I want to live with dad, because life is good here, but only good on weekends. Should we now listen to the child? Should we now take what the child wants? So if there's a court order in place, the child must go back to mom, finish, done. However, if there are certain issues, social welfare issues, then we can relook the matter. But there must be basic valid reasons therefore. Regarding the over-claiming of child support, she's welcome to claim whatever she wants to. She can claim for millions a month if she wants to. It does not mean the court will grant her that. The court will only grant you what you are entitled to based upon all the facts of the matter. Okay, so we now let's into the game. I have an additional question. What happens when the child chooses not to be with the other parent? The child cannot choose. Let's say, for argument's sake, we have a baby, and the baby is now with a mommy, and the dad can care for the child. Now the child does not want to go to the dad. Does the child choose? The child might choose now on a Monday night and a Sunday night, no, I want to stay with dad. I don't want to go to school the next day. So the child cannot choose. The child shouldn't be able to choose. We listen to him. If there are serious reasons for why the child does not want to go to dad, molestation, abuse, then of course we listen to that. But if it's because of the child's preference, then what's the use we have court litigation? Then at the end of the day, it means the child must be the only one that goes to court, and he must say, I want to be with mom, I want to be with dad. It's a parent that makes decisions. And at the same time, let's say there's a birthday party. At dad's house, he has extended family, wonderful. Some cousins are living there. He lives with his family, his sister and his nephews and nieces living there. So there's a birthday party on the Sunday. It's lockdown, meaning that those kids in that specific house will not be going to school the next day because that's a day off. We all know how this country runs education during the lockdown. Now, those specific nephews and nieces are saying, no, tomorrow, because it's not school and it is our birthday, we are going tomorrow morning early for a swim to the beach, and we come back to do schoolwork. And the child says, no, I want to stay with dad, because tomorrow they're going a bit out. But the school tomorrow for the child, wherever he's going to, because that's his part of his roster. Should we now focus on the child? The child should keep quiet. The child should just follow what the court order says. That's my quick answer. But if there's social welfare issues, that's something else. If the child says, Dad, when I'm at mom abuses me, assaults me, whatever, then the father needs to act on it. He shouldn't just listen to the child, make a decision. He needs to go to the police, social worker, go to court, whatever the case may be. And I think that is it. I see no additional questions on the WhatsApp or on the Zoom, sorry, on the Facebook or on the Zoom. Now I am not dealing with any additional typed out questions. If you have any, if the participants want to pose any live questions, you're welcome to do so now. Please put up your hand and I will entertain you for that specific purpose. If not, I think we'll have to end the webinar and call it a day. So if you have a question, please put up your hand and I will let you call in. I'm getting my screens in order here. So Zoom participants, if you don't have any questions, I will take it that we're all happy with today's webinar and we can proceed. Okay, I see one final question. I'll answer the question. If I don't see the hand going up, I will end this webinar and I will thank everyone. Okay, is it compulsory to have a therapist report for a high court application? It's not compulsory. If the court can make a decision based upon all the facts and it's not necessary, then you do not have to have a therapist report, meaning having a professional to recommend to the court. However, it depends on the circumstance of the case. If there are serious allegations of one party being unable to care for the minor kids and so on, then I would say yes, it makes sense. But it's not by default always necessary for that to be the case. Okay, I see a hand up over here. Wonderful. Okay, the person whose hand is up, you are welcome to start speaking and I'll be listening.
Okay, thanks for the opportunity, Advocate. It's just a follow-up to the question I posed on the Zoom with regard to the separation of me and my wife in September, to say currently we are waiting for the outcome of the social worker visit to both residents My question was, is it advisable to say at the scheduled hearing, which is on the 30th, to involve an attorney to be part of that?
Yeah, stay on the line. I'll answer you quickly on that, and I think I might have a few questions for you as well regarding that. So deal with this first part of it. So my advice to anyone is to always, if you can afford it, to make use of legal representation in these type of matters. It's highly complicated, and if you want to get the best possible results, solely because it's very emotive, you appear at the courts, and the other parent, you might have been involved in some domestic violence, some bad relationship, whatever the case may be. So it's always good to have a lawyer. That's from an emotional point of view. But from a strategic point of view, the lawyer obviously understands the law. He understands the Children's Act, the case law applicable to it. He understands procedure, which is extremely important, and how the courts work and what the courts look at. I tend to have a problem with my clients always what I believe as a professional, as an experienced lawyer, that's relevant in a court scenario. They believe the total opposite is relevant to the Pacific Court case, and they're wasting time in court and they're wasting a lot of energy. So if you have a lawyer, the lawyer knows what to focus on and what to be successful in your case. Um, Please, if you have any additional question regarding that, the Pacific commenter, please go ahead and I'll try to assist you.
Okay, sorry.
Well, if I didn't answer your question, you're welcome to add additional question to that.
No, I think you did. Thanks.
You are welcome, sir. Thank you for your comment. Um, if there are no, yes, I see another. No, I don't see any other hands going up over here. If there are anybody else who wants to pose a question, please put up your hand on the Zoom and I'll deal with it live. If not, I think we had a very successful webinar today. Unfortunately, I couldn't promote it earlier. I just got a slot this morning. I had to be in the High Court this morning, and the matter got settled. And I've managed to set up the Zoom with 2 days' notice. Otherwise, I would not be been able to do it today. But thank you very much for all those participants, those persons who have posed questions before the time, those watching it via Facebook Live, those questions which the typed out questions via the Zoom platform, and also the caller that Pacific called in now and posed your Pacific question. Thank you for that. I believe that the more questions I get, the more opportunity I get to answer those questions and to enlighten someone, and someone will benefit from that. Thank you very much for your time. Have a wonderful day, and I hope to see you at our next webinar.